Yes. Hello, my beautiful friends. Welcome back. We have a tremendous live stream planned today. Jack Smith just got blown out in Florida. We're going to see what Judge Eileen Cannon had to say about it. Of course, we remember her from the Florida classified documents Mar-a-Lago raid. She's not done yet. They were trying to get that document released. She said no. The big Jack Smith dumb book report from the illegitimate special counsel, as we know, not a real boy at all. Now losing the final battle in Florida. We'll get into it. We're also learning that Joe Biden and the White House apparently knew a lot more about this raid than they let on to. They said that they appointed this guy and that he was independent and going to independently prosecute and validate the probable cause and the criminal charges. And Joe Biden had nothing to do with it. Turns out, lie, another one. So we're going to connect the dots there. We've got an FBI memo coming up. Before we turn our attention to Fulton County, because we're supposed to have an evidentiary hearing this very week, just days from now, to battle over the records that, of course, the FBI seized pursuant to a valid search warrant. Pitts and Fannie people, all of her entourage down there, have sued to get those files back. And now the DOJ has responded. They're saying, quash this lawsuit, cancel the hearing. They're not getting their ballots back. All your ballots belong to us now, courtesy of the FBI. And so we're excited to get into it, making sure the tubes are working. Very glad that you're here and with us. Hopefully your weekend was outstanding and you are bursting with energy to tackle the week. We certainly know that we are. And it is working. Eureka. Good to see everybody in the chat. Without any further ado, let's get into it because we've got some business to attend to here today. Let's do it. Jack Smith blocked in Florida. Another loss for the illegitimate special counsel. Judge Eileen Cannon issuing this order, not a long one, 15-pager. We'll hit the highlights on it, saying we're not releasing his little volume 2 book report. Illegitimate Jack, the illegally appointed special counsel from Joe Biden, now losing again. We're going to go into this and hit the highlights, but another shocking story broke. We're now learning that according to this FBI memo recently revealed to us by our friends at Just the News, shows Joe Biden and the Democratic Party, they were the ones behind the prosecution and the attack on President Trump. And so to set the table, we've got this story here explaining Joe Biden was behind it all. A new FBI memo confirms to Just the News, they were reporting on this all the way back in 2022, that Joe Biden weaponized the White House to go after their political opponents. Trump's not doing that. He's correcting this wrong. Here you can see a memo says explicitly, this event is dependent upon the timeline of Joe Biden's brief, his decision, and the coordination between the White House counsel and the DOJ. Joe Biden's lawyer working with the DOJ to have Jack Smith go after his political opponents. We got this report. It was released now to us, courtesy of Just the News. We've got a Fox News report confirming the same. And if you haven't seen it, here's what it looks like. This one from the FBI, an import form, form type FD 1057, chronicling an electronic communication that happened here. And look at this right here. F. POTUS, attorney call script, explaining here, here's the call script to be used when contacting Trump's lawyer, the former president of the United States, his attorney, asking for their future cooperation to a consent search of Mar-a-Lago. And of course, Trump was very accommodating with them this entire time. He brought the FBI down. He brought prosecutors down. He said, look around. Here's our skiff. We're putting all the files right in here. It's perfectly safe. It's perfectly secure. You shouldn't have any problems about it. While he invited them into his home to monitor the location, they were scouting it out. They were actually acting like double agents, working against him to say, oh, perfect. Thank you for inviting the investigators in here. We're going to continue to investigate, even though you extended the graciousness, a beautiful invitation to come down here. We're still going to weaponize that against you. So here are some options. They said we could ask to speak to Trump's lawyer. Trump's lawyer and Trump stated at the time that Washington did get classified records in June. Trump said many times he's willing to assist and he's willing to cooperate. But they did not want that to happen. They wanted to go raid his house. They wanted to prosecute him because they were freaked that he was going to beat him and reclaim power, which he did. Now, logically, if we have additional questions about this, Trump would be a witness to interview. Now, here's a request. We ask from the FBI, the DOJ, to contact Evan Corcoran and Christina Bobb. Those were Trump's two lawyers. And remember, they breached Trump's lawyer's attorney-client privilege. They said that he didn't have it because Evan Corcoran, was going to be committing a new crime. A crime fraud exception says that they can breach Trump's literal attorney-client privilege. They forced Evan to come testify. And they said, go after them. Christina Bobb, Evan Corcoran. They write, the Washington field office has developed no information from a witness who has observed this information since the return of the classified records in June. Again, totally damning. They've got no new evidence. They go down there looking for classified material. Trump gives it to them. Then they have to go make up some other witness. Here they say, we have developed no information from a witness. So what should we do? Let's contact the lawyer and do other things. Now, Washington has made numerous suggestions to the DOJ, so the Washington FBI communicating to Joe Biden's DOJ that over the course of the investigation, the most expedient way to get the recovery of the classified documents, just go through Trump's lawyer. He'll give you the materials. He was already cooperating. The DOJ has persistently disagreed. They did not want a cooperative relationship here. They did not want Trump to just be able to hand over the documents. They said, enough. We've had enough negotiating. Now it's time to go raid. A new National Archives referral from Deborah Steidel-Wall, we remember her, for all the presidential records and the classified documents. If NARA pursued these presidential records, which are likely to still be at Mar-a-Lago, they could also recover additional records, which, if we want, can also go after classified material. Now, Washington has been rebuffed in this request by the DOJ. Whose DOJ? Joe Biden's DOJ. Now, Washington does not believe and has articulated to the DOJ that we have established probable cause for the search warrant. The DOJ has opined that they do. Okay, we do not believe that we have established probable cause right there. We don't have evidence to go get a search warrant. The DOJ overrides the FBI and says, what the hell? Yes, we do. We need to raid this man. Requesting that the wide scope include the residence, Trump's home, the office, and the storage space. They went into Melania's closet. Finally, if the goal is to identify and get the records quickly, the 5 weeks spent fixated, says these FBI agents in Washington, fixated on probable cause for a search warrant, all of that has been counterproductive. It was never about the files. It was about prosecuting him for classified documents. Joe Biden, the DOJ, and the rest of the scammers, in this case, probably the CIA, John Brennan, and Clapper, and the rest of them, the morons who signed the 51 laptop letter, they were actively colluding. Our CIA, former CIA, are you ever former CIA? Not really. Colluding to stop the president. Now, the DOJ has inquired as to an ops plan for a search warrant of Mar-a-Lago. Washington relayed that we are not in agreement for probable cause on a search warrant. DOJ from Biden planning it. FBI agents saying, we can't even do this. Saying that Washington does have an ops plan in place, but however, it's dependent upon the timeline of President Biden's brief. Dun, 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 dun. Joe Biden, you're busted, you piece of. Here, his brief, his decision, and coordination between the White House counsel and the DOJ. So the FBI was waiting for Joe Biden's brief and the White House counsel and others so that they could override all of the privilege and go get the files. The rest of this redacted into oblivion. What else were they talking about? What else can't we see? Thank you. These people lied through their teeth to all of us for years, and now they're getting caught, and still nobody's been indicted over this at all. And it's very frustrating to see that. So Joe Biden orchestrated the whole thing. They also then brought out an illegitimate prosecutor, so-called special counsel Jack. He was never a U.S. attorney, never properly appointed. Eileen Cannon threw him off the case because he's illegitimate. And they still were working to get the Volume 2 document released. We remember the foreign-born Judge Chutkan in Washington, D.C., released Volume 1. Jack, after he lost that case, because he, of course, didn't think about presidential immunity, he then was racing to get the evidence out, all in an attempt to smear the president and to stop their political opponents. But now Judge Cannon has said, nope, you're not getting your illegitimate report out. Writing this one, 15 pages from West Palm Beach Division in the Southern District of Florida, Judge Eileen Cannon, who is the author of this document. Let's get rid of my eraser's not working, so I guess we'll just live with that one. But here is the order from Eileen Cannon explaining, all right, Jack, loser. This cause comes before the court following two unopposed motions. And this is a beautiful thing right now because Trump, in this case, was a defendant. Now he's running the DOJ. So the old DOJ was run by Jack Smith's people. And of course, they would never agree to not release Volume 2. But Trump has reclaimed power, back in charge of the DOJ. And now he, under his DOJ, can agree with Trump in his personal capacity as a defendant that we shouldn't release this. So now we have basically everybody in agreement. Don't release the files other than Jack's people and the other people who are trying to intervene in this case. So she says, all right, here's what we got. We got former defendants. This is a closed criminal action because Jack Smith was thrown out of here. But they say, all right, Trump came out, the president, on his own, and he said, don't release Volume 2. Walt Nauta also got attacked by Jack's thugs, and Carlos de Oliveira, both of these were co-defendants in the case. They also came out and they said, don't release it. Now, Judge Cannon explains, the court has reviewed the motions and the records. I've seen everything. And the U.S. government, now the DOJ under Trump, is saying, do not release this document outside of the DOJ. Jack is illegitimate. He's not a real boy. And Bondi has also explained that this is part of our deliberative process determination, and we don't want these files released. Now, fully advised in the premises, Judge Cannon says Trump's motion to stop the release of these files is hereby, dun 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 dun, granted. Here's what happened. This section, says Cannon, recounts the facts and the procedural history pertinent to the instant motions and helps us remember what the hell happened in this case. It was a disaster. On July 15th, 2024, remember, until Cannon came in here and stopped this charade from happening. On July 15th, 2024, we are months away from the 24 election. This court granted the motion to dismiss the second superseding indictment against Trump. It was a glorious day indeed. We covered it here. Jack Smith, not a real boy. Unlawful appointment and unlawful funding. Illegally appointed, and he spent tens of millions of dollars to unleash this hell. Illegally. Now, the court determined in an order confined only to this proceeding, she wasn't making a decision for Judge Chutkan in D.C., that Jack Smith's appointment violated the Appointments Clause of the United States Constitution, warranting a dismissal. She explained that all actions that came from Jack's defectiveness, his appointment, and his brain, including his seeking the superseding indictment, hinges on the unlawful exercise of power. That means that everything that he did was ultra virus. It was outside of the law. He had no power to do it. She said the Appointments Clause was violated, and the only remedy is to dump the case. The court also concluded that Jack's case and his use of a permanent indefinite appropriation, okay, he had an unlimited slush fund that the DOJ had set aside, and he just kept tapping into it. Could you imagine if you're on the receiving end of this? The government has unlimited money to come after you. What are you supposed to do? Anybody else gets taken out. President Trump, of course, has the backing of a large portion of America and was able to weather the storm. But this would take out almost anybody else. Now, this case has generated, she writes in a footnote, close to 800 docket entries. This order is focusing only on the most recent stuff. And basically, she's saying we're fast forwarding through a lot of the other history. Jack violated the Constitution. Merrick Garland violated the Constitution. Joe Biden violated the Constitution. And they all sat there and lectured us, saying that they were doing this fair and independently and no one's above the law, while they're all literally prosecuting him from a perspective of being above the law. Jack's timely appeal, he appealed the dismissal order, but he never sought a stay, and then ultimately elected to dismiss the appeal without prejudice following Trump's win. Okay, so Jack was appealing. I am a real boy. What are you saying? What? So then, of course, they dismissed it, and now the court's dismissal order was always in force and appropriate, but they're not done. Jack wanted to get this document out, Volume 2. Now, despite the court's final dismissal order, this is where she slams Jack. It was entered back in July of 2024. Jack Smith sought no stay. She said, you're illegitimate. You can't prosecute this case. Did that stop Jack? No, of course not. He's a corrupt hack. So he kept going. So Jack then accelerated efforts after the order. She already disqualified him. He just kept going. All the way through and until his exit in mid-January 2025. So Jack, was still tapping in. Who was paying for all this? He spent months continuing to work on the case. Judge said, you have no money to work on the case. You've been illegally apportioned funds. You're stealing money from us. He didn't care. To prepare and finalize a report utilizing discovery materials generated in this case, Jack was still working even though all of his money was cut out. So he kept going. That report makes up volume 2. Cannon says, I've already explained this. Volume 2 includes substantial amount of discovery in there. There was a protective order. There's disputed material. There's attorney-client privilege material. Jack even explains it includes references to Bates-stamped information provided in discovery. It's got transcripts, search warrant materials, business records, video footage, toll records, grand jury subpoena information, all of it that they want to release to smear this administration. This is, of course, stuff that Trump has said is all protected by privilege. It is harmful evidence that has no probative value. And there's a protective order. The order still exists. It says no disclosure to the public. And so Cannon says, all this was very clear. All of it, she wrote, shall not be disclosed to the public at all. So then in December 2024, Trump wins the case. Glorious day. As the presidential transition neared, defense counsel for Trump learned through media reports that illegitimate Jack and his team were still going to release volume 2. They've been working on this case, working it up, writing their little book report. They're going to leak it to Congress. So defense counsel from Trump sent a letter to Jack Smith. They said, what? You can't do any of this. The case has been dismissed. Smith's authority to even work on it is invalidated. He's illegal. So in response, Jack said, no, we're not done yet. He provided defense counsel with limited access review of volume 2. He said, well, I'll let you come look at my report under strict conditions, and I'll preserve the report and blah, blah, blah. So they said ridiculous. Nada de Oliveira. They filed an emergency motion. They said, Cannon, you can't allow this guy to release this material. He's been bundling all of this up to attack Trump, essentially, and he's going to release it even though you said not to. They noted the obvious fact that criminal proceedings remained pending against them. They made other arguments. They say, well, Trump's case was dismissed, but we're still regular defendants. We're not the president. We're not executive branch officials such that the DOJ can't prosecute themselves. Right? Trump is now going to be inheriting the DOJ. How can he be the defendant of his own DOJ? So Jack dismisses it, but the other co-defendants say, hey, we're still here. What do we, chop liver? Trump also opposed the release of volume 2 as well. He said, this is going to be prejudicial against us because Jack kept working on this after you said he can't. Ultimately, January 21, 2025, we have additional briefing, and pursuant to its supervisory control and non-public information, the court granted the emergency motion. So over a year ago, they said, well, we're going to keep considering this. The court noted that Garland had unprecedented insistence. Joe Biden's attorney general at the time said, we have to release this. And we're going to release it whether there's a finding of guilt or a conclusion of a criminal case. Now, the court didn't address the other defendants' arguments about the ultra-virus nature of this, saying, well, Jack's illegitimate and he still wants to release it. Of course, all that was pending appeal at the moment. So the court back then, a lot of history, directed the parties to submit a joint status report. Let me know how the appellate proceedings are going. Almost a year goes by. December 22nd, 2025. We finally get the joint status report. Bunch of separate motions. Bunch of people are filing to intervene. Democrats are coming in. They're non-parties. They say, you have to release this. What kind of a country is this if we can't see the illegally constituted evidence that Jack Smith got from his illegal appointment? And they're all crying about this today. Just you see in the media. We should see this evidence. From what? Joe Biden's almost personally approved investigation of the president and appointed an illegal prosecutor to handle it. That order acknowledged an immediate basis underlying the January 21 order, but didn't apply to the other co-defendants. But other parties were coming in. Other parties were wanting to stop the release of the work, and other parties wanted to release the work. Now, we continue to fast forward. The instant, timely, now here, unopposed motions that we're talking about, the first motion came from Trump. Trump said, don't release it. Second motion came from Walt Nauta, says, don't release it. Now, the United States, the prosecutors, who are, the old DOJ, now inherited by the new DOJ, they also released a response. They said, you can't release this. This is the unlawful work product of an unconstitutionally appointed actor called Jack Smith. It has discovery. It has protected material. And Bondi has also said that a lot of the material inside the work product, right? Jack Smith says that he worked under the DOJ. She says, well, I looked at it. That includes a bunch of privileged and confidential material. So even Bondi is now saying, don't release it. Now, the motions are ripe for resolution. All that is what Cannon laid out for us. She says, nobody's challenging our jurisdiction, so I can rule on this. And she says, let's get into it. Now, as a broad proposition whose force depends on the circumstances presented, she explains, generally speaking, federal courts may exercise supervisory powers. That's what I'm doing here. Now, I have to exercise some restraints. I have to follow the rules, federal rules of criminal procedure and more. And it explains what this power is. It encompasses the power to restrict access to certain discovery materials if that is appropriate. Lots of case law. All of these in italics are all citing sources and cases. That's the rule. Now, to the extent a court in a criminal case, in the exercise of its authority, grants relief, such an order is not conceptualized as a traditional civil injunction, but it's a substantive protection. Okay, those are the rules. So I'm going to follow the rules. Here's what the rules are. Now, all parties agree authorizing public release of Jack's Volume 2 would contravene the conclusion in my final dismissal order. I already decided this. I said Jack Smith acted without lawful appointment. He acted without lawful funding, and he took actions illegally, which makes all of those actions invalid. Everything that follows is illegal. So they also raise a host of additional arguments against the release. They say, well, there's a bunch of other reasons not to release it. First of all, Jack's illegitimate. He stole a bunch of money and stole a bunch of time and weaponized the DOJ against his opponents. Got that. But also the protective order. It was clearly entered early in the case. It restricts dissemination of any of this. We also have protected grand jury information in there, separate rules under 6E, saying that you can't release that information. And there's also a mandate on the defendants to delete all discovery if they wanted to view Volume 2. So now the defense doesn't even have their records with which they can rebut the allegations in the disclosures. The need to protect this material under attorney-client privilege, and more. And there's also a question about the raid. Fundamental notions of fairness and all of these things, nobody was adjudicated guilty on any of these things. So a million reasons why not to release them. Court says, I reviewed the motions, and consistent with my authority to govern discovery, release of Volume 2 outside the DOJ would plainly offend my prior order and the protective order. Both of those are still in effect, and this would cause irreparable damage to former defendants from disclosing this information. There's still a contested grand jury and privilege concerns, and it would undermine the basic notion of fairness and other things, and I'm not going to do it. So she says, here's why. First, despite this court's holding in July 24 that the actions of Jack Smith must be set aside, he's illegal. Jack Smith, stand down. You lost. Go back to The Hague. Go back to Europe over there. We don't want you here. She says he didn't stop. Jack Smith and his team went ahead for months, undeterred. They prepared Volume 2. They used all of the discovery that they got in connection with this case, and they kept spending money to do it. Now, how is that not some sort of a crime? Pick one about abuse of funds or theft or fraud or whatever. She said, you can't work on the case. He spent money to do it. Where's that money back? We should go get it right out of Jack's bank account. Defendants learned of this continued work in December 2024. Media was reporting on this. They raised their objection to Jack Smith, but he just kept going. He said, well, I mean, we're going to release the report, obviously. But if you want to review it, you can. And you have to delete everything if you want to come look at it. So the defendants came out. They said, this is ridiculous, Judge. They moved for emergency relief to stop the release of Volume 2. Jack Smith kept going. In fact, they separated from the DOJ. Then Jack referred the case to the Southern District of Florida. Then he delivered Volume 2 to, I guess, Merrick Garland at the time, back in December. Everybody was filing emergency motions. Trump is transitioning in to take over the DOJ in January. And apparently there was no counsel of record with any actual knowledge about anything on this case. So Jack kind of says, all right, I got to get this out. So he passes it off to some other people in Florida. Cannon says, to say this chronology represents at minimum a concerning breach of the spirit of the dismissal order is an understatement, if not an outright violation of it. It is an outright violation. Jack should be held in contempt and ordered to come explain himself, Judge Cannon. Act like Judge Boasberg, just a little bit. The dismissal order focused on the charging document on which the criminal proceeding hinged, which was the superseding indictment, and it dismissed it. The report was explaining a dismissed indictment. But Cannon says, I went on to explain that all, literally all, in quote, she's quoting herself, of Jack Smith's actions were ultra-virus and they must be set aside. But nevertheless, rather than seek a stay of the order, saying, well, Cannon, can you pause this portion? Let me continue to work on this, or seek any clarification at all. Jack didn't do that. Him and his team chose to circumvent it for months. They stole our money. They stole our time. They took the discovery that was generated in this case. They wrote their little report about it. They gave it back over to Garland. Then Garland gave it to Congress and then beyond. All outside the law. So every time you hear them screaming about Trump's not following judicial orders, where was Jack Smith on this one? The court need not countenance this brazen stratagem or effectively perpetrate the counsel Jack's breach of this court's own order. It is brazen. It is in violation. He should be held in contempt. She continues. Now, second, Volume 2 contains voluminous discovery that remains under the protective order as well. Under that order, absent consent of the United States, which there is not, the DOJ is not agreeing to this, or approval of the court, which there is not, there shall be no disclosure to the public. No one is going to benefit from them. It was illegally gathered. The parties operated under the tight rubric of that protective order during this litigation. Cannon says, I painstakingly ruled on matters about this. We issued motions to compel. We had a bunch of other pretrial motions. And at no point during the entire litigation did any party, much less Jack Smith, take the position that they could freely disseminate discovery materials disconnected from substantive motions. Not only that, as we now know, Jack and his team demanded, as a condition of a limited review of the volume, that all defense counsel delete discovery, reinforcing the restriction of discovery. So Jack doesn't want anybody to have these materials, except when he does, after he writes his fake report. All of this shows the following. The court, I am empowered to enforce this order, and the disclosure of Volume 2 would do the opposite. We've got protective orders. We're not releasing discovery materials without the consent of the U.S. or approval of the court. And now the defendants, because Jack made them delete all their files, have no opportunity to even respond to any of this. And so we are going to grant this. And third, if you have any doubt about it, as the defense points out, disclosure of Volume 2 would run the real risk of disseminating material that's protected by attorney-client privilege. Nobody can test those things. We already were forced to delete material thanks to Jack. And when the court, she writes, adjudicated these prior motions, there was no department counsel in a position to even comment on these things because Jack Smith was gone. And no such counsel of record appears now. So accordingly, Volume 2 in its current form, even apart from its character as work product of an unconstitutional government actor, that's you, Jack. And he spent tens of millions of dollars that we should go claw back. Contains material whose disclosure would impinge upon untested and colorable claims, and so we need to stop that. Fourth and finally, writes Cannon, there's also the matter of manifest injustice to the people who were the defendants in this case. Jack Smith, acting without lawful authority, obtained an indictment in this action and then initiated proceedings, resulting in ultimately the dismissal of the charges because he was just terrible. He had to make it up. He couldn't even prosecute a made-up case on January 6th or the Florida case. As a result, the former defendants in this case, Trump, Nada, Oliveira, they still enjoy the presumption of innocence. It's held sacrosanct in our constitutional order. So for obvious reasons, says Cannon, this court doesn't need to take action in contravention of that. If I release it, it would do that. All of these defendants would be subject to abuse based on widespread discovery materials aggregated by an illegal prosecutor. Now, while it is true that former special counsels have released final reports, it appears that they've done so either after electing not to bring charges or after adjudications of guilt by plea. But the court strains to find a situation in which a former special counsel like Jack has released a report after initiating charges that did not result in a finding of guilt like this one. Everyone was contesting these things. Everyone still proclaims their innocence. But regardless, it is certainly not customary for a prosecutor who obtains an indictment and initiates a criminal prosecution that is later dismissed to publicly release everything, disseminate large swaths of discovery that were generated. Not common, much less after directing defense counsel to destroy their evidence and in contravention of a court order saying that you're unlawful. So if you think it's strange that a special counsel was appointed and never released a report, how strange is it to have an illegal prosecutor raid a former president, gather a bunch of evidence, fight against the disclosure of that evidence until, of course, he loses his case. Then all of a sudden he wants all the evidence out everywhere. We've declared him illegitimate. That's pretty unusual, says Cannon. So actually what we're doing is not unusual. How about you appoint a real boy next time who's not a liar? Now, in the end, therefore, if nothing else, we return to basic fairness. Federal courts may exercise their supervisory powers to make sure that we can deter illegal conduct by government officials, which is what we're doing here, to protect the integrity of the courts and to deter illegal conduct. Man, that is Judge Cannon quoting another court case here, D. Bernardo. But that sounds like Jack Smith is illegal, because he is. The court does so here, mindful of the caution of my power, but for the foregoing reasons, Judge Cannon against Jack Smith, you lose, Jack, explaining Trump's motion unopposed to prohibit the release of Volume 2 is hereby granted. And Walt Nada's motion is granted in part as it relates to him. And Bondi and their successors and all persons who were involved in this, you are enjoined from releasing Volume 2 outside of the DOJ or anywhere in perpetuity, permanently blocked Jack Smith. Any additional relief requested in neither motion or by anybody else, a bunch of people were trying to move to intervene to get this released anyways, is hereby denied. All ordered by Judge Eileen Cannon, the glorious 23rd day of February, 2026. And so Cannon says, sorry, Jack, you lose. Case is over. And other people who are coming to intervene in here, you're also denied. So all of the lefty lawyers who are screaming and shouting, let us come in here and we have a different argument. Nope, you don't. Jack's illegal. No evidence comes out as a result. And so Fox News put together a little bit of a montage for us, courtesy of Jim Jordan. Jim says, it's always worse than we thought. It's true. These newly released documents confirm that the Biden DOJ launched the raid. It was politically motivated from the very start, had nothing to do with the files, as usual. All has to do with power. Same thing can be applied to the Epstein files. It's all being used for power. The transparency shown by Bondi, Todd Blanche, and Director Patel is required to help the country understand the lengths of what this prior administration went to. And do you think this is going to result in any mea culpa from any of the lefty journalists or lefty legal analyzers who say, well, Jack Smith was so amazing? No, they'll just say this is a biased judge, Judge Cannon, who is overruling justice, overruling the truth. not acknowledging Jack was illegal. Jack was taking orders from Joe Biden. Jack was colluding with the J6 committee. Jack was colluding with Fani Willis. The whole thing was a giant incestuous prosecution trap to go after their opponents. And now they are losing in a major backfire. Here is the report.
Breaking tonight, a Fox News exclusive. We have new information that appears to directly contradict the Biden administration's insistence it had nothing to do with the Justice Department investigations into then former President Trump's alleged retention of classified material and the subsequent raid on his Mar-a-Lago home. Correspondent David Spunt has details tonight. Good evening, David.
Brett, good evening to you. These emails obtained by Fox News paint a different picture of the relationship between the Biden White House and the Biden Justice Department. These two offices made it clear at the time, at least publicly, they were not connected and stayed away from any political interference. However, new emails obtained by Fox News from May 2022, 3 months before Mar-a-Lago was raided by the FBI, illustrates coordination between the White House counsel's office and the DOJ regarding an interview of Walt Nauta. Now, remember, Walt Nauta is a current White House aide to President Trump, who was then former President Trump's aide in Florida. Nauta was later charged alongside Trump by special counsel Jack Smith. The May 10th, 2022 email reads in part, coordination with DOJ and White House counsel are in work to start the process to confirm and interview current administration employee Walt Nauta. This event is dependent upon the timeline of President Biden's brief decision and coordination between White House counsel and DOJ, and in turn, Evan Corcoran's position on the override of privilege assertion and whether or not he seeks an injunction to prevent access. That was written by an FBI agent, and Evan Corcoran, of course, one of Trump's lawyers at the time. This coming August, Brett, will mark 4 years since FBI agents raided Mar-a-Lago. A few days after that, then Attorney General Merrick Garland said this.
I personally approved the decision to seek a search warrant in this matter. Second, the department does not take such a decision lightly.
And we're getting new reaction to these emails. Judiciary Chairman Jim Jordan in the House says, in part, it's always worse than we thought. These newly released documents confirm that the Biden DOJ's raid on Mar-a-Lago was politically motivated. We're also hearing from Attorney General Pam Bondi. AG Bondi says the more we learn about the DOJ weaponization under the prior administration, the worse the story gets. And Brett, she says this right here. It's a key part. She says we will continue disclosing key evidence to our congressional partners to deliver the truth and bring those who committed crimes to justice. That coming from the Attorney General tonight. Brett.
Justice is what we want. We want contempt charges from Cannon against Jack Smith, or we want obstruction of justice. She ordered him not to continue working on the case. He did. He was trying to interfere with proper execution of the law, and he should be held accountable for that. And so, Pam, we appreciate the disclosures over to Congress, but she also has a lot of other tools under her belt. Sunlight is the best disinfectant in many ways, but also as good, criminal indictments. So hopefully something is percolating and brewing over there. We're going to keep our eye on this one. But Jack Smith loses, and this was kind of the final bag for them. They had all their eggs in this basket, really hoping they could release Volume 2 and vindicate Jack Smith. But now Cannon saying, no, you're not a real boy. You weren't a real boy back then. You were illegally stealing money to make this prosecution happen. And when I ordered you to stop, you kept going. How come? No repercussions for him. He's walking around America testifying to Congress like nothing's going to happen to him. But we're going to keep our eye on this until him and the rest of his cabal of goons are all facing justice for the crimes they perpetrated on America. And hopefully Pam Bondi and the Judiciary Committee are on board with this, because no one is above the law and accountability must come for them. All right. Jack Smith drives me nuts. All right. Now let's talk about what else is percolating out there, because we got some fun stuff in Fulton County. And let's make sure we're properly queued up with our documents in hand, and let's get right to it. The DOJ strikes back in the Fulton County raid case. We know that Rob Pitts and the rest of the Fulton County fraudsters on the Board of Commissioners filed a lawsuit against the United States of America. They said, you can't come in and take our ballots. DOJ says they're not your ballots. They're our ballots now, and we're not giving them back. We got two big motions to go through here today. all in preparation for an evidentiary hearing, which is scheduled this week, which should be a good one. You can see over the weekend, the judge came down and said, I've got everybody's motions on this. Of course, FBI went into Fulton County, took all of the ballots. We know they're riddled with fraud. They're probably reviewing them right now. And many people, including Norm Eisen, Democrat super lawyer, Abby Lowell, one in the same, sued to say, we want a trial essentially on this, an evidentiary hearing where we have witnesses come in. You have the FBI agent who wrote the FBI search warrant affidavit, all of them coming in to testify. And then some other judge who didn't actually issue the search warrant would say, give them their files back. Well, the DOJ said, how about we vacate this evidentiary hearing? It's coming up. How about we quash any of your subpoenas to drag us in here? The judge has ordered a briefing schedule. Bunch of stuff is going to be coming this week. Thank you for subscribing. We'll make sure we keep our eyes on it. February 24th, February 25th, all in preparation for a hearing February 27th coming up soon. So it's going to be a full-blown hearing unless the judge vacates it. So the DOJ says you have to vacate it. There's no reason for us to even have this hearing. We got two briefs here. One, the United States response to their amended motion, and the Pitts and the Fulton County fraudsters, they're all saying we should have our files back. There is a rule called 41G that says if you think that you were aggrieved by an unlawful search or seizure of property, then you can file a motion. Has to be in the same district. You can go to a different judge and present evidence. The court must receive evidence on the factual issue, which means we have to have an evidentiary hearing, right, to present evidence. If the court grants the motion, the court must give the property back. FBI would have to bring all those trucks back, dump them on Fanny's desk. But the court may impose reasonable conditions to protect the property and other things. The DOJ says this is ridiculous. This is not even appropriate here. Rule 41G, are you out of your minds? They say, here's the government responding to all of this. They write, first of all, Judge Salinas, okay, the judge who issued the search warrant, she's already decided this. She wrote and found, which is why she executed the warrant, that an FBI agent's sworn affidavit, which we've read here several times, already found it establishes probable cause, saying that the Fulton County election records, in fact, did contain evidence of violations under federal criminal law. Already been adjudicated. In fact, the judge authorized the FBI to execute a search warrant and literally go seize those records, which we've done. Now, Rob Pitts and Fulton County Board of Commissioners, and again, notice who is not in this list of plaintiffs here. The clerk of the court. And the clerk of the court was the entity that was in possession of the ballots. So why is Rob Pitts saying those are my ballots? And Fulton County Commissioner saying those are ours? They're not yours. They were already in possession of the clerk of the court. Separate entity. They had to go get a second warrant to go get the files from the clerk of the court. But the clerk is not suing because they are the ones that have the actual possessory interest here. But they're not anywhere to be found. Why is that? So here they explain. We now are here fighting this because the petitioners, Rob Pitts, asked this court to return the records under Rule 41G we just read. Their goal is to disrupt an ongoing federal criminal investigation. But the law is clear. They can't do that. They fall far short of making the evidentiary and extraordinary showing that would allow this court to order us to give them the files back. Here's why. First of all, they're not even the right parties under 41G. They lack possessory or even custodial interest in the records. Quite simply, they're not their files. Think of it like standing. The United States seized the records from the clerk of the Fulton County Superior Court. We made this argument at the very beginning of the lawsuit. Yet the clerk is conspicuously absent from this case. Where are they? So the court should deny this on that basis alone. There is no jurisdiction. Rob Pitts has no possessory right to these files at all. He should go talk to the clerk and they can sue. Now, even if Rob Pitts and Fulton were proper parties, which they're not, they would plainly also not be able to establish any entitlement to the records. Only the narrowest circumstances permit a district court to invoke equitable jurisdiction. And when we talk about equitable jurisdiction, it means the court can kind of equalize things. The court can use its power under equity to right the wrong. Okay, you stop doing that thing and you start doing that, or you give them that back. It's kind of like mom comes in with the two brothers who are beating each other, like in my household, 3 of us really, and says, settle down. And you give your brother that back. Okay, equitable. And they can't do that here. We have a search warrant. Among other requirements, they have to show this standard. If they want these files back, they have to show a callous disregard for their constitutional rights. We got violated. They claim that their Fourth Amendment right was violated, but they don't even have any Fourth Amendment rights. Fourth Amendment protects the people. They're a political subdivision. They're the Fulton County Board of Commissioners. So that's another threshold issue. They're not even a person. So we should dismiss this for lack of jurisdiction there. Now, regardless of any of this, we were very careful about it, says the DOJ. The United States was scrupulously careful to comply with the Fourth Amendment when we got these ballots. It seized the records only after obtaining a warrant based on a judge's probable cause determination. The agents went, they executed the warrant. Then they went and got an amended warrant out of an abundance of caution because the clerk had the files, not the commissioners. They had no reason to doubt that the judge was wrong twice. They went to a judge twice. How can that be callous disregard for somebody's constitutional rights? They didn't just show up and take them. They went to a judge. That is the antithesis of callous disregard. Now, their contrary arguments are meritless. Rob Pitt and the rest of the morons there, they disagree with the probable cause finding. That's fine, they can, but that's no basis to invoke this rule, 41G. The judge said that the issue was decided. That issue was already settled. Judge approved the warrant, got evidence, and signed off on it. That's not a callous disregard of anything. That's following proper procedure. So this court should not open the floodgates for everybody who wants to come in, file a lawsuit in a different judge's district, in a different judge's chambers, as a way to get a sneak peek at ongoing criminal investigations. Now, if we go back there, right, to the extent that Rule 41G could ever overcome a magistrate judge's probable cause determination, so some plaintiff like Rob Pitts in Fulton, they can override a judge just by saying, well, we disagree with the search warrant. This court's review would be extremely deferential if you did that, considering both the ordinary deference that applies and the high bar under Rule 41G, right? In other words, a judge hearing evidence and signing off on a warrant settles it. Some other whiner filing a lawsuit doesn't just automatically eliminate that presumption of validity. Under any standard, they failed. Fulton. They argue the affidavit doesn't contain sufficient evidence of willful violations. Remember, they kept saying, well, it's very speculative. But probable cause doesn't require proof beyond a reasonable doubt. All it requires is a fair probability that evidence of a crime will be found. That's it. Is it fair if you go and look through Fulton County ballots based on all of the witnesses that we saw articulated in the affidavit? Are we going to find some evidence of a crime? Is there a fair probability? Absolutely. The judge signed off on it twice. It doesn't require evidence of a mens rea, which is a guilty mind. When we talk about crimes, we have two components, a mens rea and an actus reus. Mens rea is often your intent. Did you intentionally go do that? Did you recklessly go do that? Did you negligently go do that? What was going on in your brain? Then there's an act. You actually did something. So you intentionally were going to do the thing. Then you did the act, which consummated the thing. Two components. But in a warrant, you don't need a mens rea element of this. They cite a bunch of cases, 11th Circuit, and more. Now, it's also irrelevant whether the affidavit proves an impact on the outcome of the election. That's not the criminal charge. Well, you committed fraud that resulted in the outcome of the election. That's not the law. The law doesn't say anything about the outcome of the election. The affidavit focuses on violations of these two crimes. 52 U.S. Code 20701, 20511. Outcome determinative or not. Like, it's a crime whether it changes the outcome or not. Doesn't matter. It's not a statute. So instead, they keep losing. So Rob Pitts and Fulton, they're left to minimize and then mischaracterize various statements in the affidavit. So since they're bad on the law, they got to go attack the evidence, right? If you have bad law, then you pound the facts. If you have bad facts, but you have good law, then you pound the law. If you have neither, you just pound the table and say, we're all being discriminated against, and this is retribution for political prosecutions or whatever. Now, petitioners then do that. In doing so, they make the classic mistakes of viewing the statements in isolation. They pick them out, they try to attack them, and they try to take them out of context. They're ignoring other non-innocent explanations, instead focusing only on this was human error or whatever. Now, petitioners demand for a Frank's inquiry into whether the affiant intentionally or recklessly misled the judge is also groundless. So we want to go now dig into and basically depose the FBI agent who wrote the affidavit. Well, he's probably a liar, so now we need to go investigate him. They say, what? That needs a callous disregard standard, and they don't even come close to that. They have to show that there was something egregious or otherwise that merits this. And the court can do all of that, by the way, without holding a hearing. They have not pointed out to any deliberate falsehood or anything in the affidavit that is so egregious that it would negate the whole thing in order to go investigate that. Saying there's nothing there that would do that. In fact, to the contrary, the supposed misrepresentations and the omissions that were flagged by them are illusory. They're immaterial. They don't even matter. So even ignoring all of the other independent grounds for dismissing this lawsuit, there was absolutely no hearing required here. Now, the court can just as easily reject the rest of their arguments. They said, well, these cases are old. The 2020 election was like 6 years ago, so stop looking into it. They say that doesn't negate probable cause, and that type of defense may only be raised in a prosecution. It's not applicable here. Nobody's being prosecuted right now. So why are they saying, oh, you can't charge me with a crime? Nobody's been charged with the crime. Why are you so scared? Nor is there any conflict between the seizure of records and any other sovereign interest in safeguarding election integrity. There's no substance here. All it is rhetoric, and nothing that they're alleging here meets the standard of callous disregard. Now, they're also failing the rest of the standards. They barely even try to meet the standards. They can hardly claim a meaningful interest in the records. They're not even theirs. There is no irreparable harm. The election is over, so they don't need the files for any reason. And they've also admitted that they're about to destroy the records. Like they're saying, we want to destroy these. We haven't been able to destroy them to cover up our fraud because everybody keeps suing. So they lack a remedy here. They can't go in here and ultimately demand the files get turned back over to them. And this is an attempt to intrude on a criminal prosecution. We, the United States government, Trump's DOJ, is not aware of any successful attack on any ongoing criminal investigation based on these grounds. The court should deny their motion, vacate the hearing scheduled for this week, dismiss the case and their lawsuit, and reject their attempt to go in and interfere with the federal government's criminal prosecution. Here's more. The FBI is investigating irregularities that occurred around 2020. Unlike previous lawsuits and investigations into whether any errors occurred, this investigation is concerned with violations of the law. One section requires election records to be maintained properly for 22 months, and another one prohibits casting fraudulent ballots. The FBI agents conducted numerous interviews of individuals with information related to 2020. That also included individuals who stated that they witnessed misconduct firsthand witnesses. I watched it. I'm going to come and testify about it. Witnesses 8, 9, and 11. So 3 people who saw a murder. In this case, it wasn't a murder. It was actually of an American election. Individuals who stated that they also analyzed public election information and discovered other errors. 3 witnesses, 1, 5, and 7. And Georgia Secretary of State officials who also investigated the outcome and defended the outcome of the election. Witnesses 4 and 6. The investigation focused on 4 categories of deficiencies. We talked about them all in the affidavit. Here's one. First, the FBI is investigating whether the county officials did not properly retain ballot images. We know that many of them were deleted. Why? Probably because there was digital inflation of the votes, and they didn't want to match the digital numbers with the physical numbers. Physical numbers could be validated through the ballot images, so they just deleted them. So the digital numbers are all that remains. Joe Biden wins. Based on witness one analysis here, there were 17,000 ballot images missing during the recount. The state election board also issued a letter of reprimand to the county. 17,000 ballot images gone. The affidavit also indicates that retention, so the affidavit for the search warrant, it says that retention defects may have resulted from criminal conduct. Here's how. Witness 2 was allowed to review the stored images. She noticed that the secure hash algorithm files that guarantee a ballot image that has not been modified were missing. You have the image, you have a matching kind of a key to the image that confirms this is this. They deleted the key. She also noticed post-election modification dates with the files as late as January 11, 2024. So somebody went back in and adjusted the files. Illegal. As the affidavit explains, the Fulton County ballots were counted 3 times. There was an original count on election night and into the following day after the water main break. There was a risk limiting audit, which was a hand recount, and there was a machine recount early December 2020. Noting all those. The second bucket. So the first bucket, we've got modified files. We've got missing hash algorithm files, SHA files, to validate the ballots. And we've got 17,000 ballots, 800 missing. Bucket 1. Bucket 2. The FBI is also investigating whether some ballots were scanned and tallied multiple times. Witness 5 was here, conducted an image analysis of the ballots and found duplicates in both the original and the recount. Although his analysis indicated that duplicates could not have changed the election outcome, the duplicates indicated a desire to make the recount numbers match. Which would constitute a violation of U.S. code. Brad Raffensperger and his investigator assigned to this review did not dispute this fact. Ballots were in fact scanned multiple times. The county has admitted that ballots may have occurred in duplicate. State investigators ended their inquiry and they said, well, it did not change the outcome of the election. And then that's right. Then guys like Vic Reynolds got appointed to judge. Then the inspector general at the time, Scott McAfee, became the judge who presided over the criminal prosecution of President Trump, even though he donated to Fani Willis. Third, the FBI is investigating information that unfolded unmailed ballots were tabulated as absentee ballots. Another witness explained absentee ballots should generally have folds because they must fit in envelopes. But at least 2 witnesses who are going to come and testify that they witnessed the murder of the election, they saw batches of purported absentee ballots that were pristine, not folded or creased at all. Now, to be sure, witness 4 went in and explained that there would be pristine absentee ballots in any election because some damaged ballots could be adjudicated by a vote review panel, and then they could transfer the damaged ballot onto a new ballot, right? They make a physical transcription, take those votes, put them on a new one. But under Georgia law, duplicated ballots of damaged or unscannable ballots would have been marked as such. You would say, oh, bad. Additionally, during the risk limiting audit, another witness, 8, received a batch of 110 purported absentee ballots, and 107 of those were not only pristine, but also had the same exact votes for each of the many candidates on the ballot. Weird. All on record. She'll come testify to it. Witness 8 and 9 also was at the same table, saw the exact same thing. The hell's this? What are all these ballots coming in? They just came out the printer like they're still warm. Witness 8 also got a stack of 60 pristine ballots that purportedly came from a senior living center as well, taking advantage of our seniors. Scum. Now, fourth, the FBI is investigating irregularities about tabulator tapes, which indicate how many votes were received for each candidate and how many ballots were counted on a particular machine. Witness 3 described them as the holy grail for vote counting. And another witness called Clay Parikh, shout out to Clay, found that tabulator tapes were missing for some machines. In fact, of 138 closing tapes provided by Fulton, only 16 tabulators accounted for approximately 315,000 ballots. One tabulator was used to close out 15 tabulator machines from 12 different locations, which I don't know why that would happen. Clay Parikh found that the interval between the poll closing times and the reported printed times on the several tapes were suspiciously short, such that memory cards may have been removed from one original tabulator and put into another in order to close it out. Why are they not closing them out on the machines in which they're working? Parikh also found that protective counters, aka the odometer of the tabulator tape, were identical on at least 5 tapes, and in some instances, the reported number of ballots scanned exceeded the protective counter number. How can that happen? How can you have more miles on your car than the odometer? Shows. Well, maybe because somebody is rigging the odometer. Yeah. This suggested to the witness, Parikh, that memory cards made with the tabulation. The county admitted the tabulator tapes accounting for 315,000 ballots were not properly signed by Georgia law. Follow the law, they didn't do it. Illegal. Witness 6 also stated, and there's a reason why it's the law, because that's how you validate the election. It's like, again, having a DUI blood, like they draw your blood and they're like, here's your result. What? Like, can you show me in my test where you tested the machine to show that it was actually zeroed out? And yep, they will. They're in the extended blood packets, you'll zeroed out. Here's the test. Here's where we ran it. We ran it at this time, and then we ran all the samples through at this time, and your client was right here. And then after the test is run, they'll zero it out again. They'll run another standard through and zero it out. And see, nothing. There's no weird anomalies going on, because that's what we're looking for. We're looking for spikes in the results. You zero it out before and after to show that when you run something through, it actually matters and actually has consequence. Here, no real concern about the opening or the closing. Just however many numbers come out, that's the result. Rigged. Witness 6 stated the tabulators would not have been used in the recount anyways, and the ballots are what mattered. So who cares about the tapes? Stop crying. Here's the result. During the investigation, the FBI confirmed that county election records were maintained in a warehouse. On January 28th, Special Agent Evans went and got a search warrant from Catherine Salinas. He put in his affidavit a summary of the investigation. He said, well, we think there's election misconduct. He acknowledged contrary potential explanations and prior investigations. He said certain information that was presented at the time, it found that election improprieties not to be the result of intentional conduct, saying their explanation was that this was a mistake. This is an accident. We're all just morons in Fulton County. We don't know how to sign a tabulator tape, or we don't know how to close out a machine such that it spits out the information that we need. We have to move things around. We have ballot images. We're just idiots. They say, there's maybe an alternative explanation here. They get a search warrant. Judge Salinas signs it. After the FBI agents arrived at the warehouse to execute the warrant, they learned the warehouse is a storage facility for multiple entities, and that the items to be seized were in another section devoted to Fulton County, and the clerk of the court actually manages the files. Because the original warrant authorized a search of the entire warehouse, out of an abundance of caution, they went back to the court, got a new warrant specifically for the clerk of the court. Judge Salinas issued the second warrant. They went back and executed it, and boom, left with 653 boxes filled with evidence of fraud. Petitioners, in this case the county, called Rob Pitts, and the County of Board and Registration and Elections, they're now suing to get their files back, but they're not their files. So they explain, first of all, in order to get relief for this under Rule 41G, you have to have exceptional and anomalous circumstances. It's extraordinary. First of all, you have to show that you have a possessory interest in the property. You can't go demand the return of property that's not yours. Here, it's not their property. It's a very, very high standard. It has to be something like a callous disregard. And there needs to be like a real serious need. And there needs to be irreparable harm. And there needs to be no other adequate remedy of law. And more. Lots of rules here, but they say they don't have an interest in these files. Let's go through them. In their original motion, they said that the records were held by the clerk. In other words, they admit that they're not theirs. But the clerk is nowhere to be found in this case. Despite participating in other litigation, the clerk of the court knows how to sue, but they're not suing here. Nor is the clerk merely an agent of the county or the Board of Elections. The clerk is an independent, elected constitutional officer with powers and duties under state law. And they're trying to explain here that They have possession of it. They admit it. And the clerk has still had exclusive control under the records. But the clerk is not a party to this case. So there is no basis for them to seek a return of anything. They never had them in the first place. They do not dispute that the clerk had possession. Instead, they say that we have authorization to possess and own the property. But that says nothing about this property. This property belonged to them. All they offer is a vague reference to Georgia law and something about ongoing litigation. But the law that they cite only requires delivery to the clerk. And they have exclusive control. So their glaring failure to show that they're actually their files requires a dismissal. Wow, that would be great. And they would feel like total idiots. Oh, they're not our files. Clerk, can you please go sue? Now, even if they do have some interest, they can't satisfy this high rule. The rule is about callous disregard for their rights. First of all, they're not even their files. So how can we disregard those? They're making a claim under the Constitution for the Fourth Amendment and other things, but none of it meets this high standard of callous disregard. In fact, we got a search warrant signed off on by a magistrate judge to make sure that we could go do this, which is what we did. And if you allow them to use this other rule to undermine a search warrant, now you're undermining a separate judge. Their diatribe against Judge Salinas' probable cause finding is a red herring. They're screaming at her. She decided this issue already. Asking another judge to go in and second guess another judge would allow this to happen all over the country. And their arguments at best are mine-run and misguided objections to probable cause that comes nowhere to establishing anything close to a callous disregard. So reject their arguments, Judge, because they're without any basis. Their primary argument to the contrary is that there is no willfulness. There is no mens rea. We haven't shown anybody intentionally did anything bad. Everything can be just chalked up to Fulton County's filled with idiots. But as petitioners acknowledge, the question is whether the affidavit establishes fair probability that evidence of a crime will be found. It doesn't require specific evidence. It doesn't require intentional evidence. It doesn't require anything beyond a reasonable doubt during this early stage of the investigation. But even if you analyze this under that standard, read the whole thing as a whole. In fact, it does support an inference of willful misconduct. Affidavits should not now be re-examined in a hyper-technical manner so that you can identify every little flaw. A fair reading of the entire affidavit makes it clear. If, for example, ballot images were manipulated, or boxes of identical pristine ballots were counted, or tabulator memory cards were manipulated, willfulness could easily be inferred. Any innocent explanations, even the uncontradicted ones, do not have any automatic probable cause vitiating effect. Everybody says they didn't commit the crime. Everybody says, oh, those my drugs? You're kidding me. What were they doing in my pocket? I have no idea how they got there. Total accident. Yeah, I got it. You can make that argument at trial, okay? Petitioners and their additional probable cause arguments also get them nowhere. Saying Rob Pitts and Fulton, they say, oh, these are irregularities. Yeah, they're immaterial. Yeah, because petitioners, in their view, they were of no consequence to the outcome of the election. That is of no consequence to the probable cause finding. Outcome of the election has nothing to do with it. Violations of these two provisions are not outcome determinative. It's not only a crime if you actually succeed in stealing the election. You can't break the law regardless. So they also complain about scattered pieces of the affidavit. We read it. Courts do not evaluate evidence in isolation. They look at the whole picture. So all of their isolated objections don't withstand any scrutiny at all. They explain, Rob Pitts and Fulton, they argue that witness one and the data analysis was not reliable. They say, well, witness one didn't have any role in 2020, didn't work formally for the government. But as Judge Salinas recognized, no role is necessary to analyze images. Anyone can do that. Otherwise, only insiders could investigate elections. That's why we publish the files. So we have transparency and people can hold them accountable and not take their word for it, analyze their work product. And Rob Pitts and Fulton, they don't dispute that the Georgia State Election Board, we've seen them a lot lately, they reprimanded the county They looked into it. They looked into the complaint by witness 1. They said, oh yeah, this looks pretty bad. And they reprimanded the state. Petitioners similarly attack witness 2 for having not worked an election. But again, as a member of the state election board, by the time she looked at these, she had ample experience with the matter. As another member of the state election board, witness 3, they also confirmed that there were missing ballot images. So we've got 2 witnesses so far who are literally on the state election board. They hear these complaints. They have the power to go investigate them. They do. They say, hey, FBI, there's a crime. It's also at least fairly credible. Now, the fact that witness 4 was unaware of missing images and offered a possible innocent explanation doesn't undermine any of this. There's evidence from multiple other people. And Rob Pitts and Fulton, in their half-hearted assertion that images, quote, do not seem to be covered by the law is clearly incorrect. They say, we're only required to keep the ballots, not the images. So what if we deleted the images? That's not a crime. They say the law says opposite. Such images are quintessential records and papers relating to any act requisite to voting. Because they directly relate to the casting of the ballot, they're covered by the law. Regardless, the missing images also pertain to other violations of the law. And similarly, they also are casting doubt on witness 5. Witness 5 did an analysis of duplicate ballots because witness 5 admitted, quote, he was not positive that the data he used was from an open records request. But probable cause doesn't require certainty. And they ignore that a county director of registration and elections admitted that duplication, quote, may have occurred. And that confirmed witness 6's understanding of exactly what happened. Now, although witness 5 thought duplication could be intentional to make the numbers match, but was not partisan, Salinas knows that that doesn't require partisanship in order to be a crime. It's about illegal votes. If you have duplicate or triplicate votes, those are illegal votes. Petitioners then, Fulton, they cite statements by other investigators. They say, well, the duplication was not intentional, of course, and it was due to human error. But unlike witness 5, these investigators logically equated whether a violation changed the outcome with whether a violation was intentional. This conclusion is not binding. It's not what the law says. That's not the crime that we're investigating. Pristine ballots. They also barely try to refute the probable cause about these pristine ballots. Now, aside from framing the evidence from multiple witnesses as confusing, because it is confusing to them because it's devastating for them, so they just turn around like, I don't understand what you're asking me. What are you talking about? Without rebutting that evidence, it was already corroborated. They also suggest that all those statements are outweighed by the other witnesses. So some witnesses are better than others because they're better for their case. Witness 6 doubted that a person could, quote, inject fraudulent ballots into the absentee process because it would result in bad numbers, the number of ballots versus the number of people. But other evidence shows differently, shows exactly how fraudulent ballots could have been used. For example, boxes had broken security seals. Witnesses saw people revoting ballots. Test ballots were unsecured. People could print their own. In fact, witness 4 explained in the affidavit that comparing ballots to voters would not catch fake absentee ballots if someone within the process of counting the votes substituted fictitious ballots for real ballots, right? You still have a one-to-one. You have the total number of people and the total number of ballots, and they'll match, but you flipped the votes. That's the problem. He doubted, though, that would be feasible on a large scale, but couldn't rule it out. So this investigation is about any violations, not just giant ones. Similarly with the tapes. They also say the tapes have no meaning. They discount witness 3. They say, so what? She didn't work on the election, even though she's on the state election board. They say the tapes don't matter, okay? Ballots are what matter to the final count. But they ignore that a violation doesn't, again, need to be outcome determinative. They dismiss suspicious time reports as speculation. But they don't give us any explanation for why poll closing and report printed times were unrealistically close. Why are these all looking like one person is Xing everything out? They wholly fail to address that Judge Salinas, the judge who wrote the warrant, considered these things. She looked at tabulators missing from the machines, One tabulator was used to close out 15 machines from 12 different locations. Protective counters were identical on at least 5 tabulator tapes, and in some instances, the reported number of ballots exceeded the protective counter number. More ballots went through than the counter, which means somebody's manipulating the counter. The numbers don't match. So in sum, these arguments are neither persuasive nor capable. She found that there was probable cause, and you can't undo that. Now, they've also admitted that there is no irreparable harm. What is their real motivation? They don't even want the records. They want a freewheeling evidentiary hearing. That's why they want to bring us in for testimony. They want to disrupt our criminal investigation. They want to reveal the privileged info. What they want to do is have a separate hearing for strategic gain. The rule says you can't do that. They don't come close to showing any violations or any callous disregard of anything. So if you hold a hearing here, Judge, it's going to reverse all of criminal law. And you're going to allow them to try to interfere with an ongoing criminal investigation. None of their objections come close to meeting the standard. Nothing is egregious. Once again, all they're trying to do is pick things out, but they are the ones who are misleading you. Their main argument is that the affidavit wrongfully stated that the county admitted to impropriety. But they concede. They admit that there were errors or inefficiencies, but they say they were innocent, of course. They assume that it is recklessly or intentionally misleading to say that inefficiencies are improprieties. But they say, let's look at a dictionary. Okay. Impropriety means being improper. So the affidavit doesn't say intentional misconduct is what they admitted to. It says they admitted to improprieties. It follows the dictionary. They also say that the pristine ballots are perfectly normal. And we can explain these from innocent mistakes and negligence and more. But their assertion is saying that they left out key parts in the affidavit. They say, no, we didn't. We expressly acknowledge that Brad Raffensperger's investigators, we said in there, found no evidence of fraud, dishonesty, or intentional misconduct. We put it in there. It's at paragraph 82, idiots. And we actually gave a more detailed perspective from 2 Secretary of State officials who were skeptical that fraudulent ballots were used. We put them in there. Paragraph 64 to 69 and 74 to 75. We're not hiding anything. We actually put Brad's views in there and certainly told the judge about it. Now, they also don't even dispute with us, Fulton and Rob Pitts, that they recount total changed by nearly 17,000 votes the day after it was first announced. They announced, hey, we got a recount. All the votes are in. Here's the number. Then they went, oops, we're missing 17,000. Then they went back and added them in. And they said that when they talked about that was flagrantly misleading. But we say, no, we described these defects and that there was a total vote discrepancy. All of that was told to the judge. Again, they're saying we're trying to hide things from the judge. They say, no, we're not. We told them about the tabulator tapes. And there was no omission at all on that. They also believe that a few of the witnesses have bias or credibility issues. Now, they can claim bias all they want, but they're weak. They attack Kurt Olson, shout out, who's leading this. But the affidavit merely mentions that this was originated from a referral sent by Olson. It's not relying on him as a witness. And they attack witness 7, but it's not on evidence at all. They're saying that he believes in election conspiracies, but that doesn't even make an argument. It's not an argument at all. So in the end, this court can simply compare their arguments with the affidavit. Just read what we set in. Across the affidavit, the FBI acknowledged over 20 times there could absolutely be innocent alternatives. There could be contrary perspectives. Now they're trying to say we should have basically a mini trial over this. But the rules don't allow for it. And all of their arguments fail. They also wanted to say the statute of limitations bars any prosecutions. But this is not a criminal prosecution yet. It would only bar a prosecution, not a search warrant. And they're glossing over how all of this is calculated anyways. In fact, subsequent criminal acts like adjusting the files in 2024 is another overt act in furtherance of the criminal conspiracy and would restart the limitations period and extend all of this out, moving this forward. Now, other state proceedings are irrelevant. A lot of other litigation is going on. This is a criminal investigation, and so this is taking precedent. And so you should not enact equitable powers to go in and force us to give these files back. They don't even need these. There's no irreparable harm that's happening. They just don't want us to have them. They don't want them. They just don't want us to have them. And now they're conflating their position with the clerk. The clerk can go and sue us if they want to, but they haven't done that. There's no irreparable injury here. Files should all be basically not touched anyways. And because there's no irreparable harm, there's no way to fix that irreparable harm that doesn't exist. And we do need the records. If any party faces a risk of irreparable harm, it's us, the United States. There's no need to retain evidence where there's there is a need to retain evidence when we might have a future trial. And the evidence shows we got this out of a valid search warrant, and we have to know and go through it all. Was stuff creased? Was stuff folded? A judge gave us permission to get it. And so ultimately, it makes no sense to order original evidence to go back to them when we have probable cause to show that they weren't being properly kept in the first place. If we lose the records now, we may never get them again. They'll put them in the incinerator. And so, Judge, you should deny their Rule 41G motion, signed here by Stanley Woodward up there and Thomas C. Albus, working out of Missouri, assistant attorney. And yeah, it's coming out of Missouri a bit, huh? Eastern District of Missouri. Very interesting. All that now being filed. We thought it originated out of Missouri. There was reporting on that. Of course, this is being filed in the Northern District of Georgia. Very, very interesting here. So that went out. Of course, the judge is going to get further briefing from the other side. And this was ultimately their request. They said, Judge and DOJ, we would like to demand testimony from your FBI agent. Okay, haul him in here, bring him in for the evidentiary hearing on the 27th, 4 days from now. So was that Friday coming up? Special Agent Evans is necessary. We're going to come in and try to attack the FBI agent. They're saying, you can't do this. You already got a valid warrant signed off on by a judge. And so briefing shall continue, but we've got these mega lefty lawyers, Norm Eisen, Abby Lowell, freaked that these files will be the downfall of their election rigging. So all of that, of course, we're going to keep our eye on it. We've got an evidentiary hearing scheduled for Feb 27 coming up soon. More briefs will come in here, and the DOJ will be responding. And we should have a lot of activity this week. We'll see if the hearing goes on or not. But we also have Senator Greg Dolezal. He, of course, is a state senator out there. He's continuing the investigation into the Fulton fraud. And guess where he went? Showed up to the probably illegal Senator Raphael Warnock's church out there in Atlanta and said, there's a voter registered here. All this is the same senator who wants to stop voter ID because he's got congregants who are now registering at his church. Here is Senator Dolezal from Georgia.
Hey, y'all, here outside of Senator Warnock's church, and Senator Warnock opposes voter ID, opposes the SAVE Act. But crazily enough, someone's using his address here to illegally register to vote. In Georgia, you have to register to vote at your primary address. And I've already shown you a lot of locations, UPS stores, empty buildings, empty homeless shelters that have been closed for a decade, where people are illegally registered to vote. But this is just another one. This person has been registered to vote here since 2018, is still currently registered to vote here on the 2026 voter rolls. And it's just another example of Fulton County's inability and unwillingness to follow Georgia law. But crazy enough that it's happening right here at the primary employment place of a United States senator.
Yep, nobody's even checking, and they'll just say it's probably racist or bigoted to ask somebody to register at their primary residence. Just let them register at churches and UPS stores and really wherever the hell they want, as long as they vote Democrat, of course. And if the president was out in Georgia last week, and he was talking about this. Here's what he had to say.
They raided the Fulton County place, storage house. And now the Democrats have hired a massive team of lawyers. They have the ballots. That should be no problem, right? They have the ballots. FBI came in and raided. They found plenty of stuff. And now they have the ballots. And the Democrats are fighting like hell, and I think it goes before a judge tomorrow, to not let anybody see the ballots. Why don't they want them to see the ballots after all these years? You know why they don't want?
We do.
Because they cheated.
Yes,
that's why.
They did.
They sent top lawyers down from New York to fight it. And I think it goes before a judge tomorrow sometime. They don't want them to see the ballot. They've taken the ballots. They have them now after years. They got an order from the court, signed order from a very respected judge, and now they're trying to stop anybody from looking. You know why? Because they cheated like dogs. Agriculture.
They don't want to get caught, which is why they're even filing illegal lawsuits. They don't have any possessory right to the files, but guys like Norm Eisen and Abby Lowell will do whatever the Democratic Party wants and demands, and in this case, the cover-up of the election fraud is high priority for them. But we've got a hearing on this coming up this week. Lots of additional briefing will be coming down on this. Will a federal judge order the ballots to be returned to Georgia? We'll be here to see. Thank you for subscribing and joining as we keep our eye on this one. All right, my friends, what a beautiful day it's been. And a lovely stream. If you're just getting here, quick recap on what we talked about. We went through the Jack Smith blowout in Florida. He just got blocked big time. Wanted to release volume 2 of the raid files. And now Cannon says, no, you were not a real boy back then. You're not a real boy back now. Anybody trying to intervene, good luck. Not going to happen. But these files will remain sealed. Volume 2, not going anywhere. We also learned that now Joe Biden has direct connection to this raid, courtesy of these FBI documents released by Just the News. FBI agents saying amongst themselves how there's no probable cause to go get a search warrant for the raid of Mar-a-Lago. Didn't care, did it anyways. And even were articulating that this event is dependent upon the timeline of Joe Biden's brief, who is going to be signing off on this to go and raid his political opponents. And the usual suspects in the mainstream media and on the left, all the legal analysts over there, will want to gloss over this one because, as we know, they started all of these political attacks. Now it's time to prosecute those who were involved. Read through Cannon's motion and heard about Jim Jordan and the judiciary. And apparently Pam Bondi is going to continue to release this material, send it to Congress. She says there will be justice. We'll see. Then we turned our attention to Fulton County. Rob Pitts, the illegal lawsuit. He's not even somebody who should be suing. The clerk should, but he did. And apparently he also did it, as we talked about last week, before he even had the votes to do it. They sued first, then asked the board to approve the lawsuit, and then sent emails to do that, actually. We read through those emails because it's all illegal. All they do, I guess, is get the outcome that they want and then backfill the data to support the outcome that they engineered. We read through the most recent briefing submitted by the DOJ, slamming the Fulton County board. You guys have no right to even sue, and all of your arguments are just terrible. We've got an evidentiary hearing, unless something changes, which is currently scheduled for this Friday, I believe, February 27th, which should be a big one. We'll see what the judge says in response to that. But read through the filings, read through the briefs, learned about the rule, heard from Senator Dolezal, heard from the president himself, and it's been a great stream. I think we're going to have a lot of updates this week, and we appreciate you joining us as we do. This morning, we talked about a bunch of things. Mexico, war zone, U.S. hockey, shout out. Congrats to our hockey players and Kash Patel. And shout out, what else? The assassination attempt at Mar-a-Lago. Talked about that on the members only morning stream. We have a lot of fun with our members community. Talk about stuff that we can't get to here. And we appreciate you supporting our work. You can join on YouTube or on Locals. And we'll see you tomorrow morning on the members only morning stream. But my friends, now let's hear from you. I saw some great donos come in. Thank you so much for supporting our work and sending in some super chats and some donos and becoming membos and just being here and being your beautiful self. Thank you for watching the show. Let's see what's happening on today. We got some good donos here. We got, hey, the Simpsons are here. We've got, who's this guy? Hey, Tony Stark is here. This old guy, man, good to see you. And one old guy, man, great to see you. King Biltong's here. It's been a beautiful day. Thanks for subscribing to our channel and all the things, my friends, and for joining us as we read through these court documents. I know some of these things can be a little bit tedious, but I think they're important to see what the heck's going on out there. Hey, yeah, Sarcasmo. Thank you, Sarcasmo, for that. Jack in the box. Get back in that box, Jack. Illegal boy. That's where illegal boys go. Hey, what's going on here? Ruby Hoove. What's up, Ruby Hoove? Thank you, Ruby, for bringing in 5 new members. We had a great members-only stream this morning. Horror Show GTA, welcome. Eric Bunch. We got Solon Art TV here. We got Joseph Roy, welcome, and Brannon Brown, all gifted members, courtesy of Ruby Hoove. Ruby, thank you for bringing in new members and for being a member yourself. More members. We got Killer Davis here, LG B, Tabitha Callow, what's up? Silver Creek Mystic Treats. Well, that sounds mysterious. J Binks in the house, all gifted members. Man, thank you for those. Ruby Hoove, 10 members coming in, courtesy of Ruby. Thank you, Ruby. Chubby's here. Okay, they were causing Mar-a-Lago for their illegal raid and subsequent theft, just like everything other criminal does. It was insane what we went through. They set him up on J6, CIA, FBI probably, set him up on the Russia collusion hoax the first term. Then we got the CIA colluding to give Joe Biden talking points, feeding that to Anthony Blinken. They tried to throw him off the ballot in Colorado, did throw him off the ballot. Supreme Court had to reverse that. 4 criminal prosecutions. They changed the laws in New York to civilly sue him so that they could try to bankrupt him there. It was insane. Now Trump is like, Comey lied to Congress. They're like, this is retribution. Fascism is taking over America. Hey, Ruby, what's up? Obama, Biden, and friends have been after Trump for years. By hook or by crook, they want him gone. Glad their machinations failed and are now being exposed. Me too. Yeah, me too. And it should be, I'm happy that we're seeing a lot of this, but it should be like 5-alarm fire. These people are still walking around free, like nothing has happened. And getting accolades, like going to other, like Jack Smith's teams are going to like high-end law firms getting accolades. Great job for fighting fascism. It's ridiculous. And I'm not sure we're going to see any real prosecutions at this point. We're getting pretty close. I know there's a grand conspiracy investigation happening in Florida. Hopefully that turns up something, but we hope so. We hope so. But we want justice, man, because what they did was reprehensible. Jack was illegal. He prosecuted Trump for years. He spent tens of millions of our dollars illegally. They knew he was illegal. That's why they appointed him. There should be prosecutions top to bottom. I'm like talking like Garland. Hey, Mike Story, what's up? Still no arrest. Jack is top of the list. Man, you just read my mind right there. 11 months as a membo. It drives me nuts. Right? Prosecutors are supposed to be honorable people. I know that's a joke. But they wield insane power. They lied to us for years about it. The guy was completely illegal. They made up the charges. They almost stole another election. And like, we want justice for it, man. Jacob. Hey, Jacob Castro. Thank you, Jacob. Thanks for raiding our stream. We appreciate you being here. Shout out to our Jacob Castro friends. We appreciate you joining us. Mock Schnell. Hey, what's going on, Rob? Hey, great streams, Rob. Not sure what's going on with my membership, but for the last few weeks, been able to membo free chat showing my months with you, but time for some more membos. Oh, are you saying that you're not getting like the monthly acknowledgements, Mock Schnell? Yeah, I'm not sure. Has anybody else gotten those lately? There you go. There's one for 11 months. I'm not sure what's up, Mock Schnell. Thank you for being a membo, though. And thank you always for being so generous. Look at this. 20 membos coming in. Great to have you. Jesus for me. Tanier Mercer. What's up? Tack Ranch Adventures. We got Sandy Kohlendorfer. We got 7 and Skate. Mr. Garrett McCampbell. Welcome. Joseph Daniel. We got Jeremiah Johnson. Marcia Lee. Sergeant RP Games. What's up? Snowbird. Palabu. Miria MBQ. We got Grimm's Bar. Tammy Flashy. Semper Turnus in the house. Danesis. Lost Cause. We got DJ Duke. What's up? Conquer Christie. And one Vic Nair in the house. All courtesy of Mock Schnell. Mock Schnell, thanks for bringing in 20 new Membo friends. We'll see you in the morning, new Membos. Hey, Dominion in Dark said King of Biltong and Jacob Castro told me it is not gay when he puts Anton's firm and juicy meat in his mouth from Biltong, USA. No. It's a little bit gay when you say it that way. It is a little gay. Anton's firm and juicy meat. Like it. I mean, it is firm and it is juicy. So it's accurate. It's an accurate description, but it is a little gay when you say it that way. Just say, here, have a piece of Biltong. It's a lot less gay that way. Londo, and shout out to our friend King of Biltong. Londo, Jack needs to be arrested for wearing Hillary's black communist Chinese suits. And other things. That is also an arrestable offense for wearing any of Hillary Clinton's pantsuits. Should be like 50 years minimum. Thank you, Londo. One old guy. Hey, the Beltway is like a shielding for that big brood of vipers. They are all whitewashed tombs filled with bones, a washed out vessel, while the inside is unclean and of the devil. The Beltway. Yeah, I think there's truth to that. Yeah, I think there's a lot of truth to that. It feels like in many ways it's its own little bubble. And that's why Congress acts the way Congress does. That's why the Senate does what it does. That's why all of us are screaming at them and they just don't care. Like 70, 80% of the country wants the SAVE Act. They don't care. Why is that? Because it's this big, disgusting shield, which is part of the reason we want to go there, to see what the hell's going on inside of that. It feels like it's a necessary thing to learn about, to understand the nature of this beast, to go into the belly of the beast, to figure out what's going on in there. It's part of the reason I'm so frustrated on the outside. I want to go see what is going. Who are these people? Are they all liars? Are they all just like in a bubble? What's going on? Gauntlet KI. Hey, who to press for indictments on classified records? Well, that would be Pam Bondi. So far, we have not gotten many indictments on much of anything. Some of that I think is Pam. Some of that I think is on not getting the right U.S. attorneys in. It's probably a combination of the two. But it feels like we're just going for the low-hanging fruit. Not a lot is really going on. Hey, it's the Not Gay Biltong. We are the lowest priced direct-to-consumer Biltong brand in the United States. Amazing. Biltong USA does not overcharge for junk. We make real Biltong. Go to biltongusa.com. Use code Robert. You'll save 10% off. And you'll get some firm and juicy meat delivered to your door. Hey, Mizzy. Hey, what's up, Mizzy? Hey, thanks as always for keeping up with the news. I do not listen to cable or network news and haven't in years. Yeah, that's good. It's just like 2-minute sound bites, and a lot of it's just brain numbing. I'm hoping dependent podcasters like you put them all out of business. I think there's a trend that way. I saw Sean Hannity's now doing long form interviews, sit down interviews. All right, we'll see how that goes. Mizzy M. So they're trying to like be podcasters now, which is like, all right, good luck. We'll see. Maybe it'll be great. M. Willis, what's up? Hey, I subscribe, but YouTube never notifies me when you stream. That is ridiculous. 31 months as a member, M. Willis. Do you have your notifications on? It's ridiculous. I wish YouTube gave us a little ounce of love. If we got 1 ounce of love that the left channels get, it'd be like a game changer, but we don't. Thank you, M. Willis. We appreciate that. Thanks for being here 31 months. That's a long time. Thanks for just coming and checking. We're live, same time, every day. Thank you, M. Willis. Hey, one old guy. Thank you, one old guy, for the big fat dono. U.S. refund up to $175 billion in tariffs that were collected under IEEPA. The ruling deemed tariffs illegal. Also rewrote the 4th case versus Montana 26, deeming no probable cause to enter the home if there's an objectively reasonable basis for believing someone seriously injured or faces imminent harm. From one old guy. Well, so we talked about the tariff decision quite a bit last week. I think it was Friday morning before we did our Hunter Biden stream, which was a great stream. If you guys missed that, I thought it was a lot of fun. We had amazing guests on. But yeah, I see states are asking for refunds. I think all the blue states, hey, give us our money. We want billions of dollars. And thank you, Supreme Court, for that. Punks. One old guy, thank you for the nice dono. Not as familiar with the case versus Montana case. Was that new? Oh, we did cover that. Yeah, case versus Montana. Objectively reasonable basis for believing someone is seriously injured or faces imminent harm. Yeah, was that the one? I think the cops went in. The guy had like a wallet in his hand. They like shot him in the stomach. because his girlfriend was calling the cops. And they said, nope, that's fine. Cops can go in and just shoot you. And you're like, all right, well. The girlfriend says he's dying inside. They thought he was dying inside or something. So, yeah, cops have a lot of right to go into your home. Unless you're an illegal alien. Then the Democrats will scream about it. Hey, Jim Tells You. What's up, Jim Tells You? You're by far the best production value LawTube show. Man, that's a nice compliment. I don't know about that, but... Hey, this is great. I want to thank you for helping other creators. It's trickled down to smaller channels like me. Jim Tells You. That's amazing, brother. I really appreciate that, dude. It's like, you know, we're all in this 3-part journey. We all need, so like if we're all on this road together, like think of like these, like 3 guys like walking down this road. You need somebody in the lead, often in AA parlance, a sponsor. Then you need someone in the middle position. And then you need in the middle position to have a sponsee. Okay, so it's kind of like you're fortified because you've got somebody further on the journey than you, and you've got somebody less far on the journey than you that you're supporting. So we all want to try to get ourselves in this middle position. So we're looking up to somebody, and we're paying it forward to somebody. And I could do a better job on all of it. I think we all could. But anyways, that's how I think about it, man. So that's a real nice compliment. I know there's been a lot of people who've helped us, you know, figure out what the hell we're doing here. And so we hope to pass that on in any way we can. Jim Tells You, keep it up, brother. Hopefully the channel's going great. Sounds like it's hopefully going well. At Jim Tells You, my friends, if you want to check out another channel out there. We need more voices. Right? You know, we're not of the variety that more good creators are going to drown us out. It could be true, but we still need more voices. Jim Tells You, thank you very much, man. We appreciate that. Hey, this old guy. Thank you, this old guy. Hey, thanks for your unbelievable energy to produce this live stream. I think that's funny because it's like, it's true. It's like we do tell people we read court documents and they go, what? I'm like, yeah, but we try to make it fun. And they're like, well, for like what? Like how? I'm like, oh, I don't know. I just call everybody hot dogs and fannies, I guess, is really. The approach you take by reading motions and the legal machinations of our government make me smarter and more committed to my political position than ever. So thanks for the confirmation. I found your programming 31 months ago, and I don't think I've missed any of your programming since. Man, this old guy. Thank you so much. I've never met you, but in a weird way, I count you and your family among good friends. Keep up the work, brother. This old guy, man, I couldn't agree with this more. And I was just talking about this weekend. Somebody sent me an email, and they said, hey, man, you know, like I know I feel like I know you, kind of a thing. You don't know me. And he wrote me this beautiful email. You don't know me, but, and I was thinking, I responded to him. I said, man, I do know you. Like I do know you. And this old guy, we've had a lot of back and forth. So we could meet and, you know, and just hit it right off. And I think pick up like old friends. But if you're here, if you're a part of the community, we're kind of values aligned just by the nature of us being here together. So I may not know you like by name or person, but the fact that you're here, it's like you believe the same things that we believe. You stand for the same things that we stand for. You care about the same things we stand for. So, and he said, like, I know I'm a stranger to you. And I said, I don't feel it that way at all. From my perspective, I feel like you're a friend or like a brother or like, you know, that feeling. Like I've got friends in my life that sometimes I won't talk to for like years. But then we'll talk again and it's just right back up. Just pick it right back up, right? Because you're kind of aligned. You're spiritually aligned on this journey. So I genuinely feel that. And I was thinking, it gave me chills this weekend as I was thinking about it. Because that's how I feel it from my perspective. And I'm not sure, you know, everybody feels that way, like other content creators or whatever. But that's how I feel. I feel like, man, and by the way, this plays out. We met in Vegas. We did a watcher meetup in Vegas. And anybody who was there's 50 or 60 people there. It felt like a high school reunion, honestly. Like nobody knew each other, but everybody did know each other. Everybody was like, hey. Everybody knew screen names. And once people knew each other's names, like you're a part of the show. This is part of something bigger. Like I don't know how else to explain it, but it's part of something bigger. And it's going to take a couple decades to continue to build it out. But that's how I feel it. And it really does translate. So you may not believe me, but we'll do some more meetups and you'll see what I'm talking about. You'll see people like, oh yeah, in the chat, whatever. And everybody's just friends. And it's a beautiful One beautiful, happy family. So honestly, it's an honor. It's the privilege of a lifetime, and it's really great to be in your company, this old guy. Thank you for that compliment and for the dono and for being a part of it, really. Hey, legend. Call me legend. We will. It's revealing how the left treats this search warrant compared to the search warrant used against Trump in Mar-a-Lago in so many ways. Yeah, and Bruce Reinhart signed off on that other search warrant. And what, didn't he have something to do with the Epstein files, Bruce Reinhart? I don't want to smear him, but I thought his name popped up in those, which is weird. It's like, and he was in Florida, so he signed off on the Florida raid, and he had some interesting connections. It's very strange. But that search warrant was perfectly valid, perfectly legitimate. Trump deserved it. They should have gone into Melania's underwear drawer and gotten all of her drawers. No one batted an eye about that. But then Trump goes in and is investigating clearly fraudulent elections by their own admissions, and it's the end of the world. It's unprecedented, never happened before. Well, when's the last time they stole a full election right out from under us? Does that ever happen? One old guy, hey, what is the most important? The preservation of the Bill of Rights or tariffs? I just gauged you all. Anyone who focused on the tariff portion of my Supreme Court and the rewrite of the standard probable cause in the fourth, not smart. I mean, I think Bill of Rights takes, I'd say, precedent over kind of everything. Like, those are the first 10 amendments, our Bill of Rights. They're very, very important. And tariffs, is an open debate in many ways. Like, tariffs are important, but it goes to Congress. Congress delegates that back to the executive. Supreme Court decided that delegation was a little bit too much for John Roberts' liking. So there's a lot more nuance, I would say, in the tariffs debate. And, I'm not as invested in those. Like, I'm not an economist. I don't really know if these are going to be good or bad for America or what the long-term implications are. I'm not sure anybody does. I think a lot of the economists and the market people are just like guessing like the rest of us. It's kind of this veil of intelligence that I don't really believe exists. It's too unknowable, right? And there's a guy called Nicholas Nassim Taleb who wrote those books back there. He talks about anti-fragile. He talks about signal versus noise. A lot of people in the markets think that there's signal, but they're mistaking that from noise. And oftentimes the people who are like in the noise of the markets think that they're like measuring these charts and all these things and they understand what's happening. They really don't. It's too big. It's unknowable. But there's this concept of knowing something that's unknowable that we think gives us some comfort, and it really doesn't. But my point is, as it relates to the tariffs, I've seen our country be hollowed out my whole life. And whatever this globalism is, has not seemingly improved my little position in Arizona, looking around, has not been a benefit to us. So if tariffs reverses that, my inclination is that that's a good thing. But other items like the Bill of Rights are just non-negotiable, like free speech or freedom of religion or freedom of association. Like, those are just non-negotiable. There's no nuance there to it. And that I can tell you unequivocally matters. Okay. Our free speech is connected to our God-given existence. It's ingrained in our humanity. If you strip away your speech, you strip away your humanity. I can't make that same argument for tariffs, at least not as acutely. Thank you, one old guy. Great comment. Cheryl Patrick, what's up, Cheryl? 27 months as a baby. I think that's 3 babies. I'm pretty sure. Need to get a calculator. Thank you, Cheryl Patrick. Very nice to have you here for 27 months. I'm pretty sure 9 times 3 is 27, but I don't know. Cecil says, what's going on? Thank you. Hey, Ricada. Man, we got a couple of raids over from Rumble, man. Shout out to our friends. My understanding is Ricada, somebody mentioned this morning, Neuro D said Ricada is covering, I think, a live trial right now. I'm not sure which one, but if you're looking into that, man, check that out. Check that out, Ricada Law. This old guy, once again, thank you for the very nice dono. Very generous. And thank you for being here. Yeah, and I know sometimes, maybe it's not as exciting as other shows where it's just like, fast-paced kind of topical coverage, but these are like national issues. Our whole country is hinging on some of these decisions. Jack Smith, they tried to steal a whole presidency. Fulton, they tried to steal a whole election. So thanks for spending the time with us, this old guy. Hey, this is a company called the Teabag Company, brought to you by, I think this is Russian or something, or maybe Polish. Bolzak, the Bolzak Teabag Company. Welcome aboard. Great to have you. Not how much tea are you selling with that name? Probably a lot. Chubby, hey, Tulsi released a video this morning on her YouTube, listed and talked about a lot of things she and the Trump administration have been doing. Man, thank you for that. Tulsi's posting on YouTube now. I follow some of the YouTube channels out there, and a lot of them don't actually do anything. Like Mike Johnson has some YouTube posts, some others do, but I wish that they would be a little bit more aggressive with that. Like the judiciary, the GOP. Like, get out there, get in front of the people. I'm glad Tulsi is. Thank you, Chubby. We'll take a look at that. Maybe we'll hit that tomorrow morning too. Miss Kayla. Hey, Virginia resident, I question the outcome of the election. Yeah, which one? Which one? I also question the outcome of the elections, multiple elections. Depends on which ones. Virginia, maybe the Abigail Spanberger one. I think Arizona is also just a hot spot. Bill Onesie Twosie Gates, a couple of teas with Stephen Richer out there. Both of those goons. Great tea name, says Monkey. Yeah, amazing. Grab some tea from Balzac. Amazing. Hey, what's going on? Jim tells you. Hey, hey, Jim tells you. Thanks. I stream with good logic on Thursday nights. Hey, shout out to Joe. Yeah, we were sending people over to Joe, but I think he pushed his time back again. I haven't seen him live while we've been live. Shout out to Joe. Good logic also. So many good creators out there, man. So many good things to watch out there. So you're in good company, man. We love good logic, and that's great. So awesome, Jim. Thursday nights, check it out. Sounds like a good stream. K-Bean's not into the tea. Yeah, that's fair. Yeah, that's fair. That's fair. It's pungent. It's very pungent. All right. Chat with me. Okay, who would have thought so many people would pay for the opportunity to hear legal documents be read in so many places? Chat with me. Says, hey, thank you. Locals, YouTube, Rumble, X. This is not ever what I would delve into, and yet a handsome, well-spoken, intelligent, funny, family-focused, mostly clean show came into my feed. We try to be clean. It's a family show. We got to educate the youth of America as well. The little ones. They're our future. Into my feed over 3 years ago, and now I feel I can have a semi-intelligent conversation on some subjects now. Any lacking is on my part, as Rob and the Watcher fam has been more than informative. Chat with me, man. That's such a nice compliment. Yeah, we have an awesome community, and we're so grateful for it. And I'm really grateful for it. It's humbling, it's wild, it's amazing. And I think hopefully we're adding something to the conversation that is not happening elsewhere. And it's in a positive direction where we have accountability. We can see what's going on. We can see the documents, and then that can inspire us to change, to help, put pressure on the change makers or become the change makers. Mostly clean, sometimes well-spoken, other times not. But man, we appreciate that. Chat with me. Thank you for making it possible. Thanks for being a part of our community. We're grateful for you. Really awesome to have you. And Rob, rounding it out, says, Rob, did you get my email about PepsiCo? No, but I checked a bunch of emails this weekend. A lot. And I did not see that. But let me double check. When did you send that in? Let's take a look over here. I got this one. Rob, I got this one. Is this about, I didn't know that this was, oh, I got it. Yeah, I do have it. I have it. I got it. Thank you for that. I didn't know what I was looking at. That's the PepsiCo lawsuit? Yeah, grocery prices. I did get it. Says here, the lawsuit was dismissed when Trump came into office. Walmart is being allowed to force manufacturers to charge higher prices to other retailers. It sounds like an interesting one. PepsiCo lawsuit that was dismissed. So in other words, Trump's FTC came in and dumped something about PepsiCo. Interesting, Rob. I have it. Yeah, I do have it. Thank you for the summary on that. And I know you linked the YouTube video. Thanks, Rob. Yeah, I appreciate that. Yeah, I don't know if Trump wants that stuff dismissed, or I don't know exactly what's going on because of like there's glyphosate. I know RFK was also coming out today saying we actually need glyphosate or else we're all going to starve to death and the food will melt out in front of us and we'll have bugs and destroyed crops and all the things. Hey, Jim tells you, man, thank you, Jim. Thank you, Jim. Really nice of you to say that. Well, we couldn't do it without you, Jim, honestly. So thank you for being here. Thanks for making it possible. Really, very, very grateful to have you on Locals. Nice to have you. Jim S. in the house. Jim tells you. Hey, the Veil's here with the very long one. Let's see what we can see here. Oh, this morning. Yeah, this morning we were talking about physiognomy. Okay, how certain people look and how that might impact how they act or what their disposition is. For example, psychopaths. If you put all psychopaths through like an AI filter, would you find similar physiognomy? Would you find eyes that are far apart? Would you see certain orientations and angles of eyeballs? Would noses match up? I don't really know. I have a book on it. I should have grabbed it. That actually says that. That says that people, like you can actually read into people's faces certain personality traits. I don't know how true that is, but there are people who say that it works. So that's all we were talking about. Anyways, we're in an age where Minority Report is real. Yeah, take a photo of somebody. Well, we were talking about this in the context of the Mar-a-Lago shooter who got killed. This 21-year-old kid who kind of looks like Thomas Matthew Crooks, who kind of looks like Tyler Robinson. And they all have like similar. If you put them in a lineup, obviously they wouldn't be the same, but they kind of got, you know, far set eyes and certain things. It's interesting. Anyways, lots here from the Veil says there could be serious consequences for profiling based upon how a person looks. Yeah, and I wasn't advocating for that. I wasn't saying it's true or it's not true. I'm just saying that there's a concept called physiognomy and people will analyze it. And that could have consequences. But I wonder if like the FBI, you know, these eight, like Palantir, like, are they modeling that? I would imagine it's been modeled. I just don't know the answers. Hey, Elliot, the United States First Amendment Institute versus the First Amendment Institute. Oh, is this a Columbia lawsuit on college campi issues? Doc Master Elliot, thank you for that. Hey, Mom of Many. Thank you, Mom of Many. Says, I came for the content and I stayed for the commentary. Love the show. I can't wait until I can write Watching the Watchers into the social studies curriculum for my homeschool kids. We'll start that in August, so please start putting warnings on news drops that are not safe for kids. You can use the tag NSFK. Man, that's a great idea. You know, we're going to have a baby soon too. Maybe we can create like a con law class for children. That'd be kind of fun. Con law for kids. Like you could have like a little character singing the Bill of Rights. Nice. I like it. All right, Mama Many. Thank you for that idea. We got to get him started young, man. We have to. Thank you, Mama Many. Yeah, not safe for kids. We try to keep them all safe for kids. But every now and then you just have a random Fannie Willis come in and throws the whole thing off. Thank you, Mama Many. Thanks for being here and for joining us. Shout out to the kids out there. Got to be on my best behavior, man. Sometimes I forget. And then you have depositions where the lawyer is telling Les Wexner to answer the question or else he'll effing kill you. You know, you're like, gosh, this is getting pretty intense out there. All right. So my friends, it's been a beautiful stream. Thank you for joining us. Thank you for the nice compliments, really. And thank you for being here. I think we're going to have a great week together. It's going to be a ton of fun. We've got more briefing on Fulton. Fannie, I'm sure, will be back in the news. They're trying to get $17 million out of her booty. And so it's going to be great. We're going to have a great stream. Once again, thanks for being here, making sure we got all the comments and the questions. Thank you for sending those in. Quick refresh over here. Case versus Montana. Death by police of ex-boyfriend regarding a wellness check at the word of the girlfriend. Was he killed? I thought he lived. I thought Case lived, but I could be wrong about that. Could be wrong about that. All right. So my friends, once again, thanks for being here. Happy Monday. We're going to have a great week together. Thank you for subscribing if you haven't already done that. Members, of course, we'll be back in the morning on Tuesday to get into what the Tuesday has for us. We like to kick off the mornings with the schedule, get our bearings straight, see what else is happening out there. So we'll be back to do that. But otherwise, my friends, thanks once again for being here. And big shout outs to our mods and meme smiths. Rob said, Pepsi sells a Pepsi to Walmart for $1, but Walmart tells Pepsi they must sell Pepsi to other retailers for $3. It's not free trade. That's interesting. Yeah. So, but I mean, if Pepsi wants to contract that away, like if they want access to Walmart's market, isn't that between Pepsi and Walmart? I'll have to look into it. Shouldn't comment on stuff without knowing what I'm talking about. But all right, my friends, it's been a beautiful stream. Thanks once again for being here. Really appreciate our time together, and I'm grateful for you. We'll pause for the evening. Before we wrap, thank you to our mods and meme smiths. Thank you to Donut Mind Me, John in the house. We got K-Bean, we got Carrie B, we got Neuro D, Janik, Dog Digger, all modding the fort down for us. Gigum, Elliot, Just Rhonda, and Neuro D, Janik, and Dog Digger. I think we got everybody, my friends. Thank you, mods. And my friends, thank you for being here. Thank you for subscribing. Thanks for sharing the show with a friend or family member, telling them what a jerk Jack Smith is and showing them the documents, explaining why Fulton County is so fraudulent, showing them the documents. That way we can have them come join us tomorrow and be here all together like one big, beautiful, happy family. We're looking forward to it. But tonight, I hope you sleep very well, have beautiful dreams and all of the things. We'll be back tomorrow to get into it again. And in order to do that appropriately, we are going to need to see you right back here so that together, with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night, my friends. Sleep very well. We'll see you right back here tomorrow. Bye-bye.
Thanks for watching, my beautiful friends. Now it's that time where the stream must end. You brought the heat with every chat and line. Together we expose corruption. One more time we dove in the truth where the media hides. Lit up the lies with receipts on all sides. The fight isn't over, but we made them sweat. We ain't done yet, no, not just yet. Because together we are watching the watchers, truth on our side. Watching the watchers, we won't be denied. Watching the watchers, eyes open wide. Fighting for freedom with nothing to hide. Drop a like and don't forget to share. And bring a friend who's ready to care. Tomorrow's lies are just today's news, but here we see through the scripted ruse. Together we are watching the watchers, shining the light. Watching the watchers, defending what's right. Watching the watchers, stay